Next on the calendar is number 29, People versus Sean John. Counsel, would you like rebuttal time?
4 minutes, please.
4? You have your 4.
May it please the Court, Dinos Lokzau from Appellate Advocates for Appellant Mr. Sean John. After he was arrested, handcuffed, and placed in a police car, an officer entered the basement of Appellant's residence and searched a closed container labeled Smith & Wesson without a warrant or consent. Appellant had standing to challenge that search. The people have not come forward with a single reason why residents of a multifamily brownstone don't enjoy the same kind of privacy expectations that people who live in a single-family home do.
Well, other people have access who live there to their basement. That's one difference between people who own single-family homes. Why doesn't that make a difference? How does he show an expectation of privacy to begin with in the basement, where there's no like separate units, there's no locks, there's no. I mean, it's just looks to me like a dirt floor, an open space with some partitions, and there it was.
As to the first part of your question, just because we share premises doesn't mean that the protections of the Fourth Amendment disappear. That would mean that all of us who live in apartment buildings would be exposed to searches by the police.
Would we all have standing?
We do, Your Honor. Just because we live in community, just because we're social beings, doesn't mean that the police gets to
Well, no,
search.
in your apartment, of course. Nobody else has access to your own apartment, your own space. That's something completely different. But if there was a 100-unit building with this open basement, that wouldn't make any difference?
This isn't a 100-unit building. This is a very small brownstone.
Well, where do we draw the line?
With a basement that was used for storage, the court below found, that had a lock on it, that had that was only accessible through the interior of the building, as opposed to a large building where there's a separate entrance for the basement.
So you're saying you only lose the expectation of privacy if it's open to the world, to the public?
Under the definition of Powell by this court, privacy is when the antithesis of privacy is when the public has access. In a large apartment building with a lobby and front doors that aren't locked, the public has access. In this small building where the basement was only accessible through the interior and only through the locked.
Putting aside the privacy issue, counsel, was there consent given by the neighbor who also lived in the building for the police to get into the basement?
The people can see that she did not verbally consent. So that's number one. She didn't specify what
expressly consent, not.
She did not expressly consent.
Something that she said, and
nothing
her
she said.
actions might have suggested consent.
The people are
expressly said, "Go into the basement. I let you go. I'm giving you consent."
That's correct.
That's what you mean.
That's correct. She did not expressly consent, and the people are now arguing that she implicitly consented. However, the officer did not inquire at all of her as to whether or not she.
Did he need to?
Yes.
Did he need to, based on what she had already done and said? If he had already determined that she's given me consent, does he then have to turn around and say, "You are giving me consent," correct?
This court in Adams and Gonzalez and in other cases has held unequivocally that absent exigent circumstances or an emergency, a police officer must inquire, even when the person asserts an authority over the premises. In Adams,
isn't there a second part here, though? Let's assume for a second that that the entry into the basement was allowable. The question in my mind is was the search of the gun case allowable? And as I understand it, this was an unlocked case marked Smith & Wesson, and I think the people rely on a case called Sanders, which I might be wrong on what the people are relying on. I don't want to mischaracterize their argument. But nonetheless, it seems to me that the law has moved beyond Sanders, and that a good argument can be made here that the plain view exception simply doesn't apply because the object in the case wasn't readily identifiable by the case itself. I think that's where you should be going.
That's exactly right, Your Honor. Even assuming the officer did receive consent and he was lawfully inside the basement, the gun inside the gun box was not in plain view. It simply wasn't. This was a closed container. There's no evidence, in fact, that it could be locked.
Well,
And
So-
the gun was simply not visible to the officer when he entered the basement. And the people relying on the fact that there was a label on this box, on this blue box that was not transparent, that said Smith & Wesson, and they equate Smith & Wesson with rendering this gun visible.
What if it had said Sean John's gun?
Even if it had said Sean John's gun, the officer would not be able to see the gun. It's as simple as that. Plain view doctrine requires that the contents be visible. And the contents in this case simply wasn't. The label didn't render it visible. The Supreme Court in Walter held that labels simply don't do that. So even if she did consent, even if consent could be implied, the officer could not know what was inside the container until he looked inside.
Your argument is about the seizure, about the search, not the seizure. Do you concede that he could have seized the box and then gotten a warrant?
At most, Your Honor, he could seize the box. At most, he had probable cause to seize the box. There was absolutely no reason why he couldn't wait for a warrant to open it. Time wasn't of the essence here. As I said earlier, the defendant had already been arrested. He was, in fact, handcuffed and in the police car. There was plenty of time to wait for a warrant.
The second part of your argument, it's a very interesting argument about the DNA evidence and who has to come in and testify in that in the expert testimony. Just to go for that for a second, because what strikes me is that, first off, it seems like the Williams case from the Supreme Court is very difficult for us to apply, and I'm not sure it says what you say it says. But the other part of that is, and more importantly, as a policy matter, most of the exonerations that take place in New York State, within the last few years have been a record number, are based, at least in part, on DNA evidence. And if as a policy we were going to say that DNA evidence would not be admissible unless we could produce every analyst who had handled the DNA raw data to put it together before an expert could come and testify, it seems to me that we would be severely hamstrung in any case more than a few years old, because people move on, they're in various places. It would be difficult for the defendants, the person who had been wrongfully accused, to be able to compile the people necessary to put that DNA evidence in. Wouldn't the policy implications of what you're arguing work against your side of the V, the defendant's side of the argument?
No, Your Honor. The Supreme Court has refused to prize convenience over the Constitution in all sorts of areas.
I don't think we're talking about convenience over the Constitution. We're not talking about that, because here we're talking about the compilation of data and then the analysis of data. Experts analyze it. Technicians compile it. And Judge Sotomayor talked about that distinction, relatively experienced jurist at that point who had done a lot of criminal work, and it seemed to be a rational distinction. And so the problem I have with, of course, Williams is a plurality in and of itself, and our decision that came out at the same time in Carcione pointed to the same kinds of problems. But more importantly, the fundamental problem of the wrongfully convicted would be undermined by the policy that you're advocating.
DNA evidence has the ability to both inculpate and exculpate. That doesn't mean that it's not subject to that the analysts who conduct the testing shouldn't be subject to cross-examination.
You wouldn't see this as an extension at all of what would be required to be admissible?
No, Your Honor. No, Your Honor. Quite the contrary. In fact, any witness who makes observable facts is subject to cross-examination. This Court has held that.
Cases? This isn't exactly a fair question, but so if you're not comfortable with it, don't worry about it. Don't answer it. But it seems to me that the data that's compiled in DNA evidence is quite often compiled in a manner that was referred to as a double blind. In other words, the technicians working on it don't know what exactly they're working on. In that situation, it seems to preserve the integrity of the compilation of the data. Normally that's done with DNA evidence, and then it's put together by an analyst at the end. Would you say that those people should still be examined? They should still verify the work they did?
Absolutely, Your Honor. The record evidence in this case.
What is the testimonial value of that information? I collected the DNA. What is that? It doesn't say, and this DNA matched your client. It only says I collected the DNA.
I'll answer that question in just a moment. I'll just answer Judge Fay's question, which is that the record evidence here establishes that the analysts did know the identity of my client. So they did not operate on the veil of ignorance. They were fully aware of the charges against my client and of his role as a suspect. In terms of the testimonial nature of the evidence, the record evidence here includes comparisons of the DNA profile.
That's the analyst. I'm talking about the other. My understanding is you want everybody involved in this to be available for cross-examination, correct?
Yes, Your Honor.
So what is the testimonial value of having someone who say, I collected the DNA, when that person is not saying, and the DNA that I collected matched your client?
What the Confrontation Clause requires is not that the evidence be reliable, but that reliability be tested through cross-examination. We want to know what this analyst actually did.
Well,
The
for
record
practical purpose here, the evidence shows that these analysts collected, you know, they did little pieces and they did a lot at once, and that as a practical matter, it seems to me that you wouldn't get anything out of cross-examining these people because they would have no recollection whatsoever of having done this particular test.
Your Honor, all sorts of factual witnesses can come to the stand and say, I can't remember. Doesn't stop us from that we must cross-examine them. These analysts here, their work involved human judgment. We need to test whether the work was done properly. And the only way to do that in our system is through cross-examination.
So each of the forensic scientists testing, is that testimonial in your view? Each one of those along the chain?
Let me just clarify that we're not asking that the people come up with 10 of the analysts. It's the people who decide to test this evidence with 10 people. We're not asking to bring up everyone. It's their decision. Their burden is really created by them because they decide that 10 people must do these tests.
Then they have an alternative.
They do have an alternative.
They could retest.
Precisely, Your Honor. Justice Sotomayor in the concurrence in Balcoming discussed that. Justice Ginsburg discussed it. In fact, defense counsel here suggested that Ms. Hoyk retest the sample and come back and testify as to her own personal knowledge as to what she did so that there could be a proper assessment of whether the work was done
That won't
correctly.
get you to, I'm sorry, I know you're red light with the Chief Judge's permission, just this one question. It strikes me that what you're, I get that point, but that doesn't get you to what I thought was your other issue, which is the possibility of incompetence and not intentional, or just human error through the raw data collection process. Because you've already got the DNA, all you're asking is for someone to now actually compare it and review it as opposed to just take someone else's numbers and compare it. But you can't have that anymore because the DNA has already been collected. So you're willing to concede that that part you can't cross on?
Actually, the person who collected the DNA from the gun sample testified. That was a police officer, and the person...
Well, in this case, but
Yes.
we're talking about the rule that you're asking us to adopt.
The rule I'm asking you to adopt is that when DNA is tested for the purpose of evidence at trial, the people who did the actual testing are the ones that have to come to court.
Every scientist in the chain that participates in the process?
Every scientist in the chain, but it is the people's doing that it requires 10 analysts to come and to test. That's not something that, I'm asking them. I'm not asking them to have 10 people test the evidence. But what the rule does require is that the people who are involved, or the single analyst who is involved, must come and testify. The people have not shown, by the way, why it requires 10 people.
Thank you, counsel. Counsel?
Good afternoon. My name is Shalom Tversky, and I represent the respondent.
So why follow a process where you need so many people along the way? Is that the, I know that Hayek, I think that's the way her name is pronounced.
Yes.
Does testify that this is normal course, this is regular protocol, but is there another way to do this that
Your
avoids this
Honor,
problem?
I'm not a scientist. I can only rely on what she testified to, but
understand.
she said that there are only 150 analysts who work at OCME, and they have 8,000 cases a year. There is no way that they'd be able to deal with that volume unless they parsed out separately to all these different analysts where they're batching the samples because that's the only way they can
Why doesn't the
do it.
alternative work? In the few cases
Yes.
where you're going to need the DNA, but the DNA is going to be in dispute, or there's a reason that you've got to have one person, as she's arguing, to go through it all, why not then in those cases do the retesting? Why isn't that a viable option? I understand the finance issue, I understand the convenience, but those are not going to get you over the constitutional rights.
Well, yeah, but there's one other issue that's even more important, and that's the reliability of the testing, the validity of the testing. They need, one of the things Ms. Huck talked about was with the exemplar, that was with the defendant's DNA, that they need to do, they do duplicate testing. And if you look at the appendix, you'll see all these lists, DUP, DUP, DUP. They literally are having different analysts testing the exact same exemplar, not the same one, but another cut of the defendant's DNA to see if they come out the same. That's one of the internal controls that they do in order to make sure that the results are valid.
Your point, because her point is I want to get to all of them and figure out if there's human errors or what they did along the way, and I do that through cross. But your point is, well, they do this so many times. If they're all coming up with the same result, that gets you a standard of reliability that the court should recognize.
Exactly. But, just to keep in mind that testimonial is not necessarily the same thing as reliable. The courts have rejected that as being synonymous. Testimonial has a very specific definition, and this court has held in Brown and Meekins that these DNA and analysis reports are not testimonial.
Counsel, is it your position that the DNA report relating to the DNA on the gun is not testimonial?
The only report that's testimonial is the report of Ms. Huck saying this DNA profile from the gun and defendant's DNA, I compared it and it's a match. All the other individual testing that leads her to that conclusion is not testimonial.
Then you insulate all of that, don't you? And if there's error along the way, she never gets across it.
Your Honor, this court said in Meekins that just because there might be procedural problems with DNA analysis doesn't mean it's testimonial. What makes it testimonial is, number one, was it a law enforcement official who was doing it? In Rawlins it was. In Meekins it wasn't. It wasn't here because OCME is not a law enforcement agency. Was the statement being made to a law enforcement official, like a statement made as a result of police interrogation? No. It was from one analyst to another analyst. And then finally —
Her only recourse to get to, I think, the point she's trying to make, to somehow get access to this DNA and have an independent DNA test and put on her own expert to say you're wrong?
Your Honor, the assumption that Ms. Huck or these — Ms. Huck she literally signed the bottom of every single page in both of those reports. She was reviewing every single thing they were doing. She wasn't observing it, but she reviewed the results. And the fact is, these analysts, because of their volume, because of the batching, they're doing 20 to 60 at a time. They're going to come in a year later at trial, and they're going to be able to tell you and remember exactly what they did in any particular case, or are they going to rely on their reports and say —
Did Mr. John get the opportunity to cross-examine the person who said that his DNA was found on that gun?
Mr. John got an opportunity to cross-examine the person who took the sample from the gun. He got an opportunity to cross-examine Ms. Huck, who took the samples once they were received by OCME and cut them up and put them into test tubes. And then he got an opportunity to cross-examine Ms. Huck, who said that she saw that based on the reports of this DNA sample from the defendant and the DNA sample from the crime scene, they are a match.
And just to make sure I have the answer to the Chief Judge's question, so there was an opportunity to cross the custodial witnesses. I took the gun, I took the swab, I put it into the...
There was an opportunity to cross-examine those witnesses. That's correct.
And Ms. Huck, you said that she signed off on each page, and does that mean that she actually performed the analysis?
No.
So
no.
What does it mean that
she testified that the way it works is they all get the same training. She had done every single one of those type of procedures herself. So when she looked over their data and their reports, and by the way, if you look at the reports themselves, you see witness with an initial. You see interpreting an analyst with an initial. These are all these internal controls to make sure that all these results are reliable, that she was signing off to see, did she agree with the results that these analysts were coming up with. But she was the only one to compare them and determine that there was a match. And that's why it's her testimony that's testimonial, because she was the only one that was actually directly linking the defendant to the crime. And that's what testimoniality is.
So let me ask you about this Exhibit 7, approved by Eugene Lean, I think is what it says.
What page is that, Your Honor? In the appendix?
Appendix 704. Forensic biology case file table.
This is the comparison chart that Ms. Huck prepared, where she is comparing the results of the defendant's DNA, the exemplar, to the DNA sample taken from the gun swabs.
So at the top when it says approved by, and then it has a name which is not her name.
So that
what role did he play in this?
So, and I'll just before I answer that, you see on the bottom right, that's her hand, and when you see that,
I see that. That's
right.
I understand.
He approved her, or he was on a higher level than her, so even she had to get her result approved and reviewed. That's how many layers of review they do at the OCME to try to ensure the reliability of these results.
So then this is her handiwork.
That's correct.
She chose these numbers, she put in these numbers.
That's correct.
And then sent it to the person who's named at the top, and he reviewed it and has this approved by.
That's correct. That's correct.
Counsel, what about the laboratory report? Did that go into evidence, this laboratory report dated October 1st, 2010? I think it's 647 of your appendix.
Just 1 second, Your Honor. Yes, that came into evidence, and to the extent, like in Meekins, that it's unclear who the source of this was. Now, the fact is, it is the same date as Ms. Huck's comparison, where she drew the conclusion and let everyone know that there was a match. So there's an excellent chance that this simply was just sort of parroting what she had determined. But to the extent that it's unclear from this lab report, just like they said in Meekins, this would be harmless error. This one page. This is simply cumulative. It could not have made a difference to the jury.
It's testimonial, though, right?
I'm sorry?
Testimonial report, right? It says, I found a match.
That's correct. Like I said, the presumption is that the only person it came from was Ms. Huck, because she was the one to make the determination of the match. But in Meekins, you had the exact same thing, where you had an email just confirming the match, unclear what the source was. So I'd be glad to say that it's simply harmless error and that it could not have made a difference, particularly in light of the argument we made in our brief as to the overwhelming evidence in this case. But even more importantly, in terms of her testimony, was the testimonial testimony, and that's why her testimony had to be subject to cross-examination. Your Honor, before my time is up, just to get briefly to the Fourth Amendment issue, clearly it's the defendant's burden to establish standing. He couldn't establish standing in a common basement. It was shared by at least one other tenant. We don't know who lived on the third floor. There could have been she could have gone into the basement. She could have had visitors going into the basement. The door.
Your view is that whenever an area is open to more than one person who's maybe not a member of your household or whatever, then there's no expectation of
that would be our position, Your Honor, and we have even more.
Shared interest. Why can't it be slightly diminished on the fact that you recognize someone else, the other tenant in this brownstone, also gets to walk into that basement?
At best, Your Honor, a diminished expectation of privacy.
So if
still,
it's a shared basement, could they go in and go through every single box in the basement?
Your Honor, it depends on what the basement looks like. Are there any delineations between the different tenants?
So, in other words, it would be the uniqueness of this box, not the basement that we're talking about.
That's right. That's right.
So
And just to
plain view exception, then
Yeah.
you would argue applies here?
well, first of all, with
But
the
wait a minute, let's go back to that, because
Okay.
you're saying, if she's the one who gives consent, does that mean she's only consenting to whatever's in
Right,
the
we're-
basement that belongs to her?
We're not saying that her consent allowed the police to open his box. We're saying that her consent, which was absolutely implicit, and there's really no, it's very persuasive in terms of the contact between she and the officers, that this was knowing involuntary consent. When she called the officers over, she told them, I saw him bringing something downstairs, something was in his hand. And then she tells them exactly how to access that location. So clearly, that gave them the consent. But in terms of the plain view, Your Honor, first of all, I want to make
Concerned
sure.
about the box. This is not a box except for the name on there, and I don't think the case law really supports your position exactly that Smith & Wesson allows you to open up the box.
But before I argue the merits, Your Honor, this claim is not preserved for this Court's review. They did not argue.
You know, I thought about that. The problem with that argument is that the appellate division seemed to have gotten it, so they seemed to have implicitly decided that he did have standing to raise the issue as to the box. Therefore, there's no Concepcion problem. Therefore, we're stuck with it. We got to address it.
Well, Your Honor, but in terms of it's a little bit unclear exactly what they were ruling on, whether it was standing or simply the plain view doctrine. But the fact is that a defendant under 470.052, the court has to either be notified of their claim that the defendant, if he had the authority to go into the basement, he didn't have the authority to open the box. The defendant never notified the court of that issue, and that court never expressly decided whether the defendant had the right to open the box or not. Because the defendant was only talking about getting into the basement. The police had no right to get into the basement. So this issue, that's why none of this about whether it's immediately apparent or not was even discussed down below at the hearing court level, because the hearing court didn't have an opportunity to address it, and that's why it's beyond the review powers of this court. But even so, Your Honor, this wasn't simply a label. I understand the picture of the case did not go into evidence at the hearing. But based on the officer's testimony, he said, that's the same box that my gun came in. So what do we glean from that? This was a box that was created by the Smith & Wesson manufacturer.
So if it didn't have the label, nothing on it that says Smith & Wesson, and the officer goes and looks at it and says, that looks just like my gun box, so it must have a gun. Is that okay?
That would be a harder question.
What makes it harder?
Because the question is, what's immediately apparent, and who's the eyes that we're talking about? Is it only the experienced officer? In this case, we don't have to limit it to that, because Smith & Wesson in Brooklyn, that's a very well-known gun manufacturer.
Yeah, but you might use the box for other purposes, right?
That's true, Your Honor, but it doesn't have to be. My opponent keeps talking about it wasn't transparent. It doesn't have to be transparent. It has to be immediately apparent. And the fact is, if you have a Smith & Wesson box that comes from Smith & Wesson and is blue and is sitting there in an open area of a basement, the defendant has
Did
no
they make anything
standing.
other than guns?
I'm sorry?
Did they put anything else in these Smith & Wesson boxes that are not guns, not weapons? Did they put anything else together?
I mean, I'm not aware of that. If you, again, it didn't come out at the hearing, but if you see the picture from the trial, you'll see that in the bottom of it, it's literally the shape. The gun gets to sort of fit into the bottom of the box. This was a gun box.
There's ammo in them, too, usually.
That's right. And ammo, as was in this case.
Right.
But, Your Honor, in terms of Arkansas v. Sanders, I mean, that footnote 13 talks about a gun case.
Yeah, the problem with the case is dated. I don't think footnote 13 is applicable anymore. But I understand your argument. Thank you.
Right. The fact is there have been other Federal courts and other courts that have adopted it.
Can I ask, if it says Smith & Wesson, let's assume it's got exactly what he has, and he adds another label to it that says, Sean John's poker cards. Can you open it?
Same box.
Same box, Smith & Wesson label is still on it. Mr. John adds another label to it. Let's say he's got a collection of these boxes, and he wants to make sure he knows that this box has his poker cards. Can the police officer open it?
Harder question, Your Honor. I would say yes. I would say yes because the nature of the box itself, you don't need it to be transparent. According to the cases, it looks like you need probable cause to believe that there's contraband inside the box based on its exterior.
Thank you,
So
counsel.
maybe, thank you very much.
Counselor, before you get right into the substance of your argument, there's just one thing I want to clarify with you. As I read your papers, it looks like you're only asking for a retrial on the weapon possession charge, not the menacing charge. Is that correct?
That's correct, Your Honor.
And does that mean your client affirmatively wouldn't want a new trial on the menacing charge?
No, Your Honor, but the menacing charge involves the display of a weapon, and the issues we're raising here don't go to that issue.
Okay.
But we are asking for a remand for resentencing as to that issue. A couple things. The first thing is, contrary to Mr. Twersky's assertion, Ms. Hoyk, in fact, did not generate Exhibit 7. If you look at the record on A36, she is asked, do you recognize Exhibit 7? And she says, yes. What is that? And she says, this is actually a page out of the file. And it is basically a table of the results for the DNA testing. This Exhibit 7 was generated by the analysts who did not come and testify. It is exactly why we need them to come up here.
That analyst, is that the person named at the top where it says approved by, or we don't know?
We don't know, Your Honor. We don't know.
Did she ever say that she didn't generate it? She said it's from the file, but did she say I didn't generate it?
She said that it was, she says that she didn't generate the documents in the file. She's not specifically asked as to Exhibit 7, but if you look at the, if you actually look at the exhibit, you can compare it to, if you give me 1 second. If you look at the record, page 704, which is Exhibit 7, and then compare it with page 668, they're identical. And Ms. Hoyk said that she did not generate page 668, and is asked whether she, where Exhibit 7 is from, and she says it's from the file. She just simply didn't generate
Sorry,
this
what
exhibit.
page did you give on the record where she says it's
On the record, it's A326.
A326? Thank you.
Yes, Your Honor. As to the notion that, OCME has to analyze 8,000 samples, other jurisdictions have adopted the Supreme Court law on this issue. West Virginia, Delaware, the 11th Circuit, all these jurisdictions present the analysts who actually did the testing, and their system hasn't broken down. I don't see why that would happen in New York.
The alternative there also to do a retest if the analysts or the several analysts are not available?
I don't know whether these jurisdictions actually make that possible, but the analyst who testified here said that the OCME, as a matter of course, preserves the samples. So there's no reason that those can't be retested in New York. The internal controls my colleague was talking about, in fact, indicate that this is subject to error. That's why there are internal controls, and that's why we need to cross-examine the analysts. As to
Well, what makes that raw data collection testimonial, though?
When you say raw data collection, you mean the actual taking of the
These
sample?
analysts that I'm sorry, let me make it easier. These analysts that you say should have been called or should have been available to trial defense counsel to cross-examine.
These DNA reports reflect observable facts that Ms. Hoyk didn't observe, but that these analysts observed. They then communicated their observations in the reports. These observations accuse my client of a crime. They make them testimonial. And the fact that he was a suspect before the testing even happened makes it testimonial.
It doesn't matter whether they realize that that's how it may be used.
Someone made a comparison other than Ms. Hoyk based on Exhibit 7, comparing these two samples.
But you're suggesting that we should have a different result here. They're testimonial if there was a suspect identified, but not if they weren't?
I'm saying that when the purpose, the primary and sole purpose is to use the evidence at trial, the evidence is testimonial. That's Crawford 101.
Thank you, counsel.
May I just respond to one or two issues from the Fourth Amendment?
I'm going to give you 1 more minute.
Okay. I think preservation is key here. This issue was preserved. The court below ruled that the officer equated the Smith & Wesson box with a gun. and so it was appropriate for him to seize it. Those are the words of the court. So the court the court below equated the box with the gun and thought that those were one and the same thing. They simply aren't. The gun was in a closed container. As to the issue of the Smith & Wesson label, if my Nike shoebox at home stores my correspondence, I can go to my friend's house and say, I have a Nike shoebox, so your Nike shoebox in your home also contains correspondence. That simply goes to the officer's probable cause to seize the item. On the basis of him actually having the same box doesn't mean that he can open it.
Thank you, counsel.